Good evening, everybody. I'm Hazel Genn, Dean of the Faculty of Laws at UCL, and it's my great pleasure to welcome you to the 2014 annual Mishcon Lecture. Mishcon Lectures were established in 1990 in honour of Lord Mishcon, and it was to mark his 75th birthday and in recognition of his achievements and service in the fields of law, education, religion, government and politics, both central and local. The lecture series was set up by Lord Mishcon's children, Peter, Russell and Jane, who are here this evening with us, with their family and friends. Although Lord Mishcon passed away in 2006, the Mishcon children have continued to support the annual lecture in his memory. The lectures, since 1990, demonstrate an eclectic range of interests, and the eclecticism of the topics reflects UCL's wish to encompass the wide spectrum of social, economic, moral, legal and political issues in which Lord Mishcon was interested. This evening I have three reasons for being extremely pleased to be hosting this lecture. The first reason is the subject. My very first academic job was working on a survey of victims of crime. In fact, it was the first survey of crime victims to have been done in the UK at the Institute of Criminology in Cambridge under the directorship of the late Richard Sparks, which will tell you just how old I am. So I have a long-standing interest in the issue, the topic of this evening's speech. The second reason that I'm particularly pleased to be hosting this event is the speaker. I have a huge respect for Keir Starmer. I first met him, he may not remember, but I first met him, I think, in China in about 2001. And I thought he was a very promising young chap at the time. I thought to myself, he's very nice and he's very good, he'll go far. And indeed he has. He's had a wonderful career, and we're absolutely thrilled that he's agreed to give the lecture this evening. My third reason for being pleased to host this lecture this evening is because it's being chaired by Lord Dyson, one of the most distinguished lawyers of his generation. He has been a great friend of the faculty. He has now become an honorary graduate of the faculty since he accepted an honorary degree a couple of years ago. And of course he's very closely connected with one of the longest serving members of our faculty, Lady Dyson. Although I can't actually see her at the moment. There's Jackie. Hi, Jackie. So for all of those reasons, I'm absolutely thrilled. I'm sure we're going to hear a wonderful lecture this evening, but what I want to do now is to hand over to Lord Dyson, who will chair this evening's lecture. Thank you very much indeed.
Well, good evening, everybody. Keir Starmer really does need no introduction. He's already had one, so in a sense my work has been done for me. But I will nevertheless give a short introduction. After an education which included a first-class law degree at Leeds University, that excellent institution in the most noble of northern cities, he was called to the bar in 1987. He built up an impressive practice concentrating on human rights law well before the coming into force of the Human Rights Act in 2000 and well before the explosion of human rights law that ensued. He took silk after only 15 years in practice, and then, perhaps to the surprise of many, he was appointed the DPP in 2008. The profile of his practice as a barrister did not make him an obvious choice as DPP, but it was an inspired one. After all, human rights are as important in criminal law and practice as anywhere else in our justice system. He brought a fresh and principled approach to the office. I encountered his work directly in the assisted suicide litigation. The House of Lords, in the case of Purdy, had required him to make and publish a policy for prosecuting persons for committing the offence of assisting suicide. This was an immensely difficult and hugely sensitive task. Some said that the House of Lords were wrong to require the DPP to do this at all. It was, after all, tantamount to asking him to say in what circumstances he would defy the will of Parliament and in what circumstances he would not do so. Well, he produced a brilliant, if I may say so, brilliant, carefully calibrated policy. But it was not quite brilliant enough for us in the Court of Appeal. We thought that it needed to be made a little clearer in one or two respects. So Sir Keir appealed to the Supreme Court. I am afraid I have not had the energy all the time to work out whether he was successful in his appeal. But that is not for tonight. Tonight he's speaking on a subject of real importance to all of us. Without more ado, I hand over to Sir Keir.
Jane Clough, a staff nurse in Blackpool Victoria Hospital in Preston, was 23 years old when she met Jonathan Vass. He was a technician at the same hospital. That was in 2007. They started a relationship. And about a year or so later, Jonathan moved in with Jane. Jane's parents, who I've now come to know very well, were concerned that Jonathan may be being abusive to Jane. And they were concerned that she began to wear clothing that was covering up obvious parts of her body. They didn't ask her what was going on, and she didn't say anything. In fact, she was being subjected to domestic violence, and she was covering up the marks on her body. She didn't tell anyone. She didn't tell her friends. She didn't tell her mum and dad. And she certainly didn't tell the police. In early 2009, so about 9 months or so later, Jane became pregnant by Jonathan, and she was delighted. She really wanted a child. About 7 months into that pregnancy, Jonathan started raping Jane. Not once, not twice, but repeatedly. Jane didn't know what to do. She was 7 months pregnant with Jonathan's child. She really wanted that child, and she wanted that child to have two parents when it came into the world. She thought it was just her, so she put up with it. Again, she didn't tell her friends. She didn't tell her mum and dad. And again, she certainly didn't tell the police. Jonathan and Jane's girl was born in October 2009, a healthy baby. But within about 6 weeks, Jonathan resumed raping Jane. She still didn't know what to do about it. And then one night, he raped her when the little child was in the room. And at that point, Jane knew that she had to do something, because she wasn't the only one involved anymore. So she plucked up her courage. She took the child, she left Jonathan Vass, she told her parents, and she went to the police. Jonathan, unsurprisingly, was arrested and charged with a number of counts of rape. He was furious. He was remanded in custody because of his previous behaviour towards Jane, and he was thought to be a threat. After a number of weeks, he applied for bail in the Crown Court in Preston, and he was granted bail. There's an issue as to whether a risk assessment that should have been before the court was before the court, but it wasn't. Jane was very concerned about Jonathan being granted bail. The police were concerned, the prosecution was concerned. I was DPP at the time. But at that stage, there was no appeal for a victim against a bail decision in the Crown Court, because the principle was that certainty for the defendant was more important than a right of appeal on behalf of the prosecution against what may have been a wrongful decision. Jane was extremely concerned. She'd been subjected to violence from Jonathan before. She knew he was furious that she had reported the rape, and that's why he was charged. And she made a diary setting out her concerns. She was still at that stage on maternity leave, so she didn't see Jonathan. But after several months, her maternity leave ended, and she prepared to return to the hospital, where she worked as a nurse. That, of course, was where she'd met Jonathan and where Jonathan still worked. So she was very worried about what would happen. She asked a friend to meet her in the car park every day and walk her from the car park into her ward and back again at the end of the day. After several weeks, all seemed fine, and Jane thought that she was exaggerating any fears. And she told her friend that she didn't need to bother anymore. She'd be fine. 2 days later, Jonathan waited for Jane in the same car park. When she arrived, and as she got out of her car, he attacked her. He stabbed her 71 times, killing her, leaving her little girl and her mother and father as the immediate victims. Again, unsurprisingly, he was arrested and charged, and the charge of murder was put on the same indictment as the charges of rape, and he proceeded through the courts. Jane's mum and dad, never been victims before, certainly hadn't expected this to happen, knew nothing about criminal justice. But they made it their business to go to court every time the case was on. And they sat there in the courtroom waiting for the case to be heard, and in the canteen over lunch. A few months after the case started its journey, and whilst it was still in the preparatory stages, Jonathan did a very odd thing. He pleaded guilty to murder. That's really unusual. Hardly anybody pleads guilty to murder. But he pleaded guilty to murder. But he wanted the rape charges stayed. He wasn't going to plead guilty to rape. The judge had to decide what to do. And the prosecution had to decide what to do. And the judge and the prosecutors discussed the case. The judge, who clearly thought it was a serious case, made it pretty clear that in his view, it was so serious that the additional counts of rape wouldn't make any difference to the sentence. He didn't think it was in the public interest to continue with the rape charges. The prosecution were initially against that course, but then agreed. They went to tell Mr. and Mrs. Clough, who were in the canteen, what was going on, and seek their views. Mr. and Mrs. Clough didn't have the first idea what to do, had no idea Jonathan was going to plead guilty. They were completely confused by the process. And they had 15 minutes between 1:45 and 2 o'clock to try and come up with a view as to what to do. They were instinctively against this because they felt that the only reason their daughter had been killed was because she had reported Jonathan for rape, and that if that wasn't proceeded with, it somehow undermined the whole process. Their view did not prevail. Jonathan was sentenced for murder, but the rape charges are still lying on the file in Preston Crown Court, not proceeded with. And Jane's parents wrote me a letter asking to see me. So I obviously said yes, and simply asked them to walk me through their journey through the criminal justice system. And they felt very let down at every twist and turn. They felt that Jonathan shouldn't have been granted bail. They felt that they should have been able to do something about it. They felt that Jonathan should not have been allowed to plead guilty to murder, but not have to plead to the rape charges. And they felt that they simply had not known from start to finish what really was going on because nobody was talking to them about the process and helping them understand. Now, what does that case tell us about victims in our criminal justice system? Have I simply plucked out a particularly stark case to make a point? Well, let's just look at some of the things that case tells us, or reminds us of. First, it's a grim reminder that 2 women are killed by their partner or ex-partner a week. 2 a week are killed by their partner or ex-partner. That's a statistic that has remained exactly the same for over 10 years. 40% of all female homicides are murders by partners or ex-partners. Second, it reminds us how difficult people find it to report domestic violence and rape. Jane was an articulate nurse in a hospital. She had supportive parents, but she didn't think she could report or tell anyone about domestic violence. And she didn't think she could report or tell anyone about rape, even when she was pregnant. And that's not uncommon at all. The latest statistic tends to suggest that about 1 million women a year suffer at least one incident of domestic violence. It's not 1 million incidents, it's 1 million women a year suffer at least one instance of domestic violence. And yet the number of cases brought in any given year is at best 100,000. That's a 1 in 10 statistic. And that statistic's pretty well the same for rape. About 10% of cases ever make it to our criminal justice system. Women and girls, on average, experience 35 incidents of domestic violence before they report it. The third thing that Jane's case exposes is how embedded in our criminal justice system are all sorts of principles and conventions about certainty for defendants, which were crafted and put in place well before we started thinking about victims' rights. The right to appeal a bail decision that may be wrong is an obvious example of that. The law changed on that after Jane's parents campaigned for change, a campaign that I supported. And fourthly, it shows us just how difficult it is for bereaved victims to receive information in real time whilst a case is going on. Nearly all bereaved families that I've spoken to, and I've spoken to very many now, say that it is impossible when you're in the court environment to really take in what is happening, even if someone is trying carefully to explain to you. It's simply impossible to take it in because your emotions are in such a heightened state. And fifth, I suppose, it shows us that when we assess the public interest in pursuing cases, we really ought to take into account a little bit more than the length of sentence in deciding whether a case continues or not. Now, is Jane's case out of the ordinary? Those are statistics. It's certainly not extraordinary for women to kill themselves as a result of having been through the criminal justice system. Tracy Shelby was a young woman who gave evidence in a case in Rochdale in relation to rape. The jury acquitted. 4 days later, she climbed onto a roof of a shopping centre from where she fell to her death. That was pretty well the anniversary of the suicide of Frances Andrade, who was the woman cross-examined in Manchester in a sexual abuse case, who took her life whilst those proceedings were still ongoing. So let us walk through our criminal justice system and see where the strengths and weaknesses are. And I want to start by the very first step of actually coming into our criminal justice system at all, if you're a victim. I've already suggested there's a mismatch when it comes to domestic violence and rape between the incident of the offence and the number of offences being dealt with in our criminal justice system, about a 1 in 10 mismatch. Let me just give you an example of that you may be familiar with. Jimmy Savile, Sir Jimmy Savile, died, still pretty much a national hero, in the autumn of 2011. By 2012, there were so many allegations flying around about what he may or may not have done that the Metropolitan Police set up Operation U-Tree. Everybody is now familiar with the work of Operation U-Tree because of the other cases that they've dealt with. But the original and initial task of Operation U-Tree was to provide a place where anybody who had an allegation about Jimmy Savile could come and tell the police a year after his death. The U-Tree team started working in October 2012, and they produced their first interim report in January 2013, 3 months, 12 weeks. In that period, they took testimony from 600 individuals. The figure will be much higher if they continue today, but 600 individuals in 12 weeks came forward to speak to the Operation U-Tree team across 28 police forces, so across a big part of England and Wales. The police assessed that there were 214 recordable offences, offences that they would have pursued if Jimmy Savile had still been alive. How many of those victims do you think came forward whilst Jimmy Savile was alive? None. Of all those 600 that Operation U-Tree saw, not one of them had come forward. All of them preferred to live with what Jimmy Savile had done rather than come forward and tell anybody about it. All 600. And when they were probed about that, because the police went back to them with the NSPCC to say, well, why was it that you didn't come forward before, but you're coming forward now? And they said, there was a variety of reasons. But the main reason was, we didn't think we'd be believed, and we didn't have confidence in the criminal justice system. Now, that was a pretty profound moment. There was I, DPP, running the Crown Prosecution Service, responsible for all prosecutions in England and Wales. And here, January 13 is a report in which 600 people subject to abuse had said, we didn't have sufficient confidence in the system you're running to even come forward. I thought that was a very profound moment in terms of criminal justice. They didn't think the criminal justice system could cope with them. Now, of course, there are difficulties reporting rape and domestic violence. And I'm going to just evidence that by a little bit of audience participation. This is something that Rape Crisis introduced me to. But the audience participation is this. I want you just for a few seconds to think of your best ever sexual experience. Your best. Or one of the best. Get it in your mind's eye. Got it? Turn to the person to your left and tell them what it was. Now, I can tell you, when that was done with my prosecutors, these were trained prosecutors, they deal with sexual offending. They were in panic mode. panic mode about this exercise because they thought it was for real and they thought that they were going to have to disclose to one of their colleagues. And they were really concerned about it. And what Rape Crisis were trying to do was the blindingly obvious, which is to say it is really difficult, even in an environment where you're with colleagues, in a light-hearted way, to even mention what your best ever sexual experience is. Imagine having to tell one person after another about the worst, the absolute worst, and then to have to go into an open courtroom and do the same and be subject to questioning about it. So it is not an easy area. And I do accept that before we start. There are no easy answers. But let us move on. Assuming for a moment someone has plucked up the courage to come forward. The next part of the journey is an assessment by the police and prosecutors of the victim. Because under our legal system, a case can't be started unless it satisfies what's known as the Code for Crown Prosecutors, which the DPP has to issue. So I had to issue it in the 5 years I was DPP. That code has been the same since it was first written. It dictates that you can only bring a prosecution if there's sufficient evidence to provide a realistic prospect of a conviction and if a prosecution is in the public interest. Now, the first test is a judgment call. And part of the judgment call is for police and prosecutors to assess at an early stage, is this victim going to be credible? Because you're only going to have a realistic prospect of success if the jury are likely to believe the victim. If they're not likely to believe the victim, chances are you're not going to have a realistic prospect of success. So prosecutors and police over the years had to address this question in relation to personal violence and sexual violence. Is the person who's come forward credible? And they devised a series of tests. Now, this became absolutely crystal clear to me when I was dealing with the child sexual exploitation cases in Rochdale. You may remember that one of the first big cases on child sexual exploitation, the street grooming cases, so-called, was a big case in Rochdale and involving numerous defendants repeatedly abusing girls. There have subsequently been very many child sexual exploitation cases across England and Wales, which gives you a sense of how prevalent it is. But the first big one was Rochdale, and my team in the Northwest came to see me after they decided to proceed with the case, but before the trial, to walk through the strategy, tell me about the strengths and weaknesses, and generally agree the approach that we should take. And that was a good briefing. In the course of that briefing, it became clear that the CPS, my prosecutors, had previously decided not to prosecute some of the very same men in relation to the very same victims. So I said, well, before you go, can you send down the files in the other cases where you previously decided not to prosecute, and I want to go through them. So we went through them. And what we found there were the reasons for not proceeding. And the reasons in pretty well all of the cases were an assessment that the victim was not credible. And so we dug a bit deeper in terms of what were the tests that had been applied by the police and prosecutors in coming to this assessment. And that flushed out a whole series of tests which have been sort of rules of thumb for many years, because police and prosecutors were asking themselves, did the victim come forward to the police straight away or pretty soon after the event? Because that's what we'd expect a victim to do. And if the answer to that was yes, they were thought to be more credible. If the answer to that was no, they were thought to be less credible if they delayed coming forward. The police and prosecutors asked themselves, did the victim go back to the perpetrator? Because in their mind's eye, you'd never go back to a perpetrator if you're a victim. If the answer was no, then fine, more credible. If the answer was yes, then they were pushed down the credibility ladder. Then they asked themselves whether the victim was able to give a chronological, coherent account of what had happened in some sort of sensible order, or whether they're giving a jumbled account that really couldn't be put together very easily. And if the answer was yes, they were thought to be more credible. And if the answer was no, they're thought to be less credible. And then they asked themselves whether the victim had been involved in wrongdoing themselves. Had they been taking drugs? Had they been drinking? Had they been stealing things? And if the answer to that was no, that was a tick for credibility, and the answer was yes, then they were deemed to be less credible. And applying those tests, a series of decisions have been made in Rochdale and all over the country it transpires, not to proceed with cases involving personal and sexual violence. Because the police and prosecutors were looking for what I came to term the model victim. And what they'd done unwittingly was to push further and further from the protection of the law the most vulnerable. Because none of the girls in Rochdale ticked any of the boxes of credibility. None of them. Now, was this a bunch of second-rate police officers and prosecutors? No. I didn't find people who weren't trying to do their job. I found people who were faithfully trying to do their best. And in fairness to them, what they were really doing on analysis was trying to double-guess, second-guess what was going to happen to these girls when they went to court. They were bringing their experience of what happened in court into their decision-making. And they knew that all those lines would be strong lines of cross-examination for these girls if they went to court. And so they were spinning forward what they thought was going to happen in court. And therefore, I took the view that this couldn't be dealt with as a team who weren't perhaps up to scratch, that it was an endemic, deeply entrenched set of cultural beliefs about how victims behave that was at the cause of the problem. And one of the reasons that police and prosecutors and perhaps juries have been very careful about assessing the credibility of victims and arguably overcautious is because of the fear of putting an innocent person forward on a charge as serious as sexual assault or rape. An inbuilt fear of putting the wrong person in the dock. And although the 600 individuals who gave evidence to the U-Tree team about Jimmy Savile had not come forward to the police, it's a little known fact that in fact 4 women did come forward when Jimmy Savile was alive to the police. 1 of them went to Sussex police and 3 of them went to Surrey police. And that was when Jimmy Savile was alive and could have been prosecuted. In each of their cases, a decision was taken not to proceed because they each said that they wouldn't support a prosecution. Each of them in the end felt they couldn't take Jimmy Savile on. None of them knew that there was another complainant out there. They all thought they were on their own, even though at that stage it was only 3. And that decision not to tell any one of those 3 women that there was another complainant was a deliberate high-level policy decision of the police. Now, before we blame the police, we need to trace the history. 10 years before that, in relation to alleged sexual abuse in care homes in North Wales, the police had told some victims that there were other victims out there. They had even identified years or age groups when it was thought abuse had taken place, and written to all the people in that group to ask them if they wanted to speak to the police. They were slated by politicians for doing that. There was a select committee. How stupid could the police be? It's outrageous to tell any one victim there's another one out there. Distorts everything. Shouldn't happen. So battered and bruised, the police went away. I thought, well, the one lesson we've learned from that is we must never tell a victim there's another victim out there. And that's why the decision was taken not to tell any one of the Jimmy Savile victims that there was another victim out there. And that's why he wasn't prosecuted when he was alive. And of course, the inevitable happened. As soon as that came out, the police and prosecutors got slated. How could he be so stupid as to not tell one victim there's another victim out there? Classic criminal justice, skidding from one side of the road to the other in response to what has happened. Let us proceed a little further. Assuming for the moment somebody has come forward, assuming for the moment they've survived the credibility test put in place by the police and prosecutors, what happens if a decision is taken not to proceed with their case? Well, until recently, there was almost nothing a victim could do, other than go to court on judicial review. Well, you need a lawyer, you need legal aid, you need to persuade a High Court judge to quite a high standard that the decision is wrong, and it's a long route. And understandably, not many people took it. So in effect, there was very little you could do. One of the things that I introduced when I was DPP was a victim's right of review, which is a very simple policy applying to all victims, which says that if you apply within a short period of a decision being made not to proceed with your case, you can have a review without the need to go to court, without the need for giving reasons, and it will be carried out. But that policy is an internal CPS policy, it's not law, and it doesn't apply to the police, who charge 2/3 of the cases in England and Wales. What about proceeding then? So assume for the moment someone's come forward, they've got through the credibility test, and someone's going to charge, because a case is started. There's then the period between charge and hearing. Now, in some cases involving personal and sexual violence, that is a very difficult period for a victim. Very often they've been holding back for many years, telling anyone what has happened to them. They've now come forward, and all sorts of anxiety feelings are going on in their head that they're trying to come to terms with. And very many of them want to see a counsellor to deal with what is going on in their head. When they ask the police and prosecutors whether they can see a counsellor, they're given a range of options, a suite of options. Option one is, it's really not a good idea. Don't do it. The victim's jaw drops a bit. I'm going through a bad phase. I really feel anxious. I really would like to see a counsellor, somebody who can help me with this, who knows what they're talking about. What's the next option? Well, the next option would be to see a counsellor, but don't talk about this. Best not to. Talk about other things. Jaw drops a little more. Well, it's this I really want to talk about. Okay, third option. See a counsellor, talk about this issue, but be on notice that anything you say to the counsellor is going to have to be disclosed to the man that you just said did this to you, because that's the way our criminal justice system works. By that time, the jaw is on the floor. So I can see a counsellor in confidence, but then everything I say is going to be passed over to the person I said did this to me. And that is the option, or those are the options on the table in relation to counselling. We then get to court and the process of eliciting evidence. And in some of the sexual abuse cases recently, that has been a real ordeal. Most people in this room will be aware of the cases involving child sexual exploitation, where some of the girls gave evidence for 3 weeks, being cross-examined by 7 barristers, one at a time. Now, as I say, I was DPP at the time, and we were running a series of child sexual exploitation cases that were broken up because of the size of the cases, because you couldn't try them all in one go. So we broke them up, but some victims were common to more than one case. And therefore, we needed some of the victims for a second or even a third case to give evidence against different men in relation to other activity. And so we asked them. Now, when you're DPP, people usually treat you with a degree of respect, perhaps too much respect. But the victims in the child sexual exploitation cases wrote to me, personally, one of them, with the answer to the question whether they would give evidence in the next trial. Fuck off. Capital letters to me. And that was the message to me. It was the message, more importantly, to their peers, to their family, to everybody they were meeting. The one thing they were never going to do again was go anywhere near a courtroom. And that was the message. Don't get involved. Don't go anywhere near it. And they didn't turn up for the next trial. So I began thinking. I've been around the world. We went to China with Lord Wolf. That was actually more to do with the civil procedure rules than criminal law. But wherever you go, people will say, we've got the best criminal justice system in the world. And to some extent, they're right. There are really good features of our criminal justice system which we must never forget. Never forget. Not least the almost complete absence of any corruption whatsoever. But that system that I've just walked through can hardly be described as fit for purpose for a victim. What are the causes? Now, what usually happens when something doesn't go right from a victim point of view is that we look for a scapegoat. It's the first thing we do. Who's the guilty individual? Look at Rotherham. Spent weeks on that. Who's the guilty individual here? Can't be anything wrong with the system. There's got to be somebody who didn't do their job properly. And if we can only find them, we can all let ourselves off the hook. Because we don't need to think any more about our system. We just have to replace the bad individual with a better individual and carry on as before. I don't accept that rationale. I don't think it was right in relation even to Rotherham, which was a particularly low example. But the abuse in Rotherham and the failure to do anything about it went on for 16 years. That was more than the failing of one individual. There are deep-rooted issues here that we need to flush out and treat with a degree of raw honesty. Our adversarial system in criminal justice has been developing over about 200 years. The roots went down a very long time ago, and for many years, the defence had to establish rights for the defence and fight for them. And rightly so, because they were treated appallingly. To give you one example, until 1898, a defendant wasn't allowed to give evidence on oath in his own defence. The broad thinking was, he's almost certainly guilty of the offence. So all you're going to do by allowing him to give evidence on oath is to double the offence, because he's then going to commit perjury. So you're better off just getting on with the case without inviting him to actually give evidence. He can say a few words from the dock. Equally, the right to have counsel had to be fought for. And much more recently, the right to be protected in police custody, an issue that led to very many of our miscarriages in not too distant past. Police and Criminal Evidence Act was passed in 1984 and came into force in 1986. So you can see why there was a real battle for defendants' rights, and rightly so. But during all of that period, most of that 200-year period, our criminal justice system was seen as a pretty straight fight between the prosecutor and the defence. Nobody even discussed victims' rights. They weren't thought of as relevant. So they weren't considered and rejected. They just weren't considered at all. The whole system was set up, the principles were laid down before anybody started discussing victims' rights. So far as legal measures are concerned, the first real legal measure for victims was in 1999, special measures. This is the provision that allows victims in some cases to give evidence from behind screens or over a video conference, or protecting their identity. In 2000, that was 15 years ago. It's not long in the 200-year period that I've been talking about. It's a very late comer. 2001, 13 years ago, was the first victim personal statement. In the same year, the law or the practice was changed that allowed prosecutors to communicate with victims. Up until now, it was thought improper for a prosecutor to communicate with a victim. It might taint the case. So there was complete distance between the two. Only changed 13 years ago. And witness care units, which tell victims what's going on with their case, when they might be needed in court, etc., were only set up in 2003, just 11 years ago. So as you can see, victims' rights have come to be understood only very recently. The first victim group that I've been able to trace, and somebody in this room might be able to give me better evidence, the first one I've been able to trace is a very small group in 1974 in Bristol. A group of individuals first got together to discuss something called victims' rights. I can't find any earlier discussion of victims' rights at all. So victims' issues, victims' rights have arrived late in the day. We have not reconsidered our criminal justice arrangements in light of them. We've bolted on some protections, and that's good. We have a victims' code. It's a set of entitlements for a victim. It's not legally binding. These are steps in the right direction. We are piloting at the moment cross-examination in certain cases by video link, step in the right direction. But we haven't had a radical rethink about the nature of our arrangements. Haven't stepped back and said, did these really work for all of the interested parties in the piece? Now, I want to be absolutely clear. I'm not interested in changing the arrangements that simply takes rights from the defence and gives them to the victim. And that's because I understand why the rights of defence are there and why they had to be fought for. But I do think there needs to be a radical rethinking of how we run our criminal justice system. Now, there seems to be, I'm glad to say, some political stirring recently. At the Labour Party conference last year, the Labour Party committed to a victims' law if it's elected next year. And one of the tasks I've been involved in this year, along with Doreen Lawrence, is bringing together the evidence that will inform what goes into such a victims' law. And we are due to report early next year. Soon after our task force was announced, the Conservatives announced a victims panel to look into victims' issues. And then in the autumn of this year, the Coalition announced that they too were interested in the victims' law. And so there is the beginning of a political consensus. There's a bit of game playing going on, obviously, as one party makes an announcement, say the next one does, but perhaps it doesn't matter. And in many respects, there shouldn't be a party political issue in any event. But it does mean that there is the real prospect of a victims' law in the period 2015 to 2020 for the first time. So it is quite a moment. It's quite interesting, isn't it? 200 years, never had a victims' law yet. Lots of legislation setting out what the prosecution can do. Lots of legislation setting out what the defence can do. But never had anything actually labelled the victims' law. That now looks as though it's going to happen. And I'll finish just by setting out what I think any law should address in this shift in thinking. The first is, how do we bridge people into the criminal justice system in the first place? That's the big question. It's much more important in many respects than the sentencing issue, which dominates a lot of the headlines when it comes to victims. Most victims aren't coming forward. So how do we bridge them in? Are we comfortable that the police station is the right or appropriate place to report? It doesn't seem to me that it is. We should be thinking much more radically about alternatives. There's a scheme, just by way of example, in the northeast going on at the moment, where 120 local employers have been persuaded to have a domestic violence champion in the work premises, where victims can go and talk during their break or lunchtime with someone who knows what they're talking about. Sexual assault referral clinics are another example. Is it time for mandatory reporting of certain types of sexual abuse, particularly involving children. One of the problems with children is not only is it difficult to come forward for all the reasons that are relevant to adults, but for children it's even more difficult. I have now formed the view that mandatory reporting of child sexual abuse is a necessary addition to our criminal law. It's got to be carefully crafted. You don't need mandatory reporting to enforce best practice. You need it to deal with conflicts of interest, where those in institutions, in authorities, in schools, charities, sports clubs, be whatever it may, have balanced between doing something about what they think is going on and the reputation of the institution that they are working for. And on a number of occasions, too many occasions, the balance has come down in the wrong place. And I now think you need mandatory reporting to deal with that conflict of interest situation. It's got to be carefully crafted, and I wouldn't have an off-the-shelf version from some of the other countries that are running mandatory reporting schemes. Thirdly, it should surely be somebody's job to assess whether the services available to victims are adequate in any given area. At the moment, we've got a service which is provided to a section of the public, and it's nobody's job to assess whether it's adequate. Some people commission from it, some of it is statutory, but overall, nobody takes a bird's eye view of the adequacy of the provision of services to victims. And we need to think of the appropriate way to deal with victims in the court process. Now, a victims' law is a step in the right direction. I think those are the issues that need to be addressed. We will report next year, but the law on its own is not enough. We need a cultural shift in thinking. We need to be brave enough to hold our criminal justice arrangements up to the light and ask some difficult questions. We could start by renaming our criminal justice system a criminal justice service. Thank you.
Well, Sir Keir has kindly agreed to answer some questions. I suggest we have about 15 minutes of questions, and then we'll call it a day. So, questions?
Yeah. I think there's roving mic somewhere.
Thank you. My name's Linda Lee, and I'm here today in my capacity of the Chair of the Victims and Witness Service in Northamptonshire Voice, which has just been established as an independent service by the Police and Crime Commissioner. And I absolutely support everything you say, Keir. I would like to draw your attention to a couple of points and address those with you. The first is that the first Victims and Witness Charter was actually formed in this country in 1990, following the very radical thinking in America. The trouble has been the lack of political support in this country to drive that forward. And I'm pleased it is being driven forward and there is financing available. But one of my concerns is for how long and what the true stability is of this move towards looking at victims, because victims were at the heart originally. Before this was a state prosecution, it was the victims who prosecuted, but you had to have the finances to do that. At a more micro level, we've commissioned quite a lot of research in Northamptonshire as to what the problems are, and you've identified many of them. But since I'm in a room stuffed full of lawyers and judges, I would like to draw one of the biggest problems I have drawn to my attention that is easily fixed and would actually save money rather than cost money. And victims of sexual assault are criticised for getting through all the hurdles and then not turning up for the trial. And it's partly the reasons you addressed, but it's also partly how we as lawyers run court systems for the benefit of lawyers and for judges. And we don't think about the number of times victims have to be contacted and asked to appear and then put back. So they go into a warned list, they come out of the warned list, those problems, they're part heard, and they may not be relisted for 10 to 15 months. And I think that's something that we could solve quite easily if we had the will to do it.
Yeah, I mean, just briefly dealing with those 2 points. I mean, stability and whether there's the political momentum to really do something about it. I think there is. I genuinely think there is, and I do think it's cross-party. I think in relation, particularly to child sexual abuse, there is profound disquiet now about what has gone on and a recognition that things have to change. And I think there is that stability. And if I may say so, the judges as well in the last 2 or 3 years have made real efforts to improve what happens in the courtroom by a number of measures, such as ground rule hearings. These are hearings at which the judge, before the case starts, sets out in terms for the barristers how the case is going to be conducted. So I think there is that stability. I genuinely think that this is the time for this radical rethink, and I think there is the political buy-in to doing something about it. Obviously, there will be different views as to how far you go, how it fits with the current arrangements, but I do think there is stability in relation to doing something. I mean, the listing issue is a familiar issue, and in terms of whether or not cases of certain types are accelerated through the system and given clear dates on which they'll go forward and not moved. Again, that is a highly desirable goal. I completely recognise that the more times a case is moved, the lower the likelihood that a victim will turn up. On the other hand, it is profoundly difficult to organise the system in such a way that that works well. And one of the problems is if you prioritise certain types of case, that means other types of case go to the end of the queue. And where this was tried, we ended up with certain types of sexual abuse cases being prioritised. That was a good thing. And then we ran into some child trafficking cases, which, because they weren't on the priority list, ended up at the bottom of the list. So it's a question of getting that right. Josh. I think it's just coming.
Joshua Rosenberg. I wanted to ask you how far you would go. The principle is, and always has been, that criminal justice was between the state, represented by you in your previous job, and the defendant. And as you say, the victim didn't have a look in. Would you preserve that principle? Because you may say it's important because some victims want to prosecute, some don't, and the decision on a prosecution shouldn't depend on the victim. Obviously, if the victim is not prepared to give evidence, you may not be able to bring a prosecution in practical terms. But there are cases, rape cases, where you've proceeded with a prosecution even though the victim didn't want to give evidence. So do you preserve that fundamental principle? And if you do, can you successfully graft onto it the reforms that you're proposing?
A really good question and a really difficult question, and one that I think needs a lot of thought. I'm inclined to stick with the present approach, and that would mean bringing cases even where a victim didn't want the case brought or did no longer support it. One of the biggest problems in domestic violence cases, as many people in this room will know, is that the victim, in very many cases, will withdraw support, and even go so far as retracting quite obviously true allegations in order to stop the case going ahead. And that means that the underlying violence is not dealt with. And our policy when I was DPP was to continue with cases in certain circumstances, even where the victim wasn't prepared to support the prosecution. And I always maintain the case for domestic violence that if you had the 999 tape, and if the police officer had a video cam when he or she went to the premises, you could always get a conviction even without the victim in any event. So it wasn't rocket science. But I would stick with that principle. I would be interested in exploring the extent to which we could fuse some of the adversarial and the inquisitorial. I don't think we need to leap from one to the other, but the inquisitorial approach where the judge leads proceedings has encroached on our criminal law. The judge is much more active now in criminal cases than would have been the case 10, 15 years ago. And I'm interested in the extent to which we can explore that role of the judge. But I'm not, to be absolutely clear, I'm not advocating a switch to the inquisitorial system.
Question over there.
Hi, my name's Mishcon. I just want to say thank you, first of all. That was a thoroughly interesting lecture. I am studying a master's in gender, and so my question for you is, how are you going to ensure that this victim's law is intersectional enough? Because, forgive me, but you are a white, privileged male, and many of the people within the justice system are white, privileged males. And so how are you going to ensure that it's also multicultural in terms of looking at going over borders with Sharia law and to different spheres of society? Thank you.
Well, I suppose, I mean, I am a white male. Not much I can do about that. I mean, Doreen Lawrence, who is my partner in this exercise, I don't think falls into those categories and has a number of other characteristics which I think would be thought relevant to crafting a victim's law. But the way we've, and there's no way of guaranteeing that, and I readily accept, I haven't got answers to all the questions. What we've tried to do in the exercise we're conducting is precisely what I tried to do when I was DPP, which was to have open roundtable, as it were, discussions with interested expert parties who really know what they're talking about, and therefore to share the thing as we go forward, taking on board what other people are saying at every twist and turn. It's very common with policy to allow a team to come up with a policy, then to consult on the policy before there's a final policy. What I did at the CPS and what I try to do now is, before we even formulate the policy, to have the open roundtable discussions so that we can inform even the first draft. And I found that it makes the first draft so much better. It doesn't guarantee things, but I think it's a step in the right direction. Because if you are going to bring about this sort of change, you've got to bring everybody with you. And that means victims, those that represent them, but also those that are representing defendants. You've got to bring police and prosecutors, and you've got to bring judges. I mean, it's got to be something where there's a real consensus about the change. I don't think it could be done in a way that is then tinkered with forever. But it's I mean, you're right, it's a very difficult exercise. And I'll have to live with the fact that I'm a white male. I've got this far. And yes, please.
Yes, I'm Jeff Tobias, and I'm a consultant at this hospital, professor actually. And I want to talk to the possible parallel between the law and medicine and the different way that you operate and the way in which we try to operate. And I think your starting point was that we see far fewer successful convictions, even though your sense is that there are many more prosecution cases which really, as it were, should be successful. In fact, in one of your answers to a recent question, when you were talking about the withdrawal of evidence from someone who was clearly had a genuine complaint, etc., etc., what we try and do is to bring every shred of evidence to bear in trying to come to the right diagnosis, leaving aside the question of management. And the right diagnosis, in a way, I think has some parallel with making the right judgment in clinical and legal cases. I wonder whether in the principle which has been enshrined and regarded as essentially untouchable for so many years, decades, that you are desperate, of course, to avoid any possible wrong conviction of an innocent party. There has, of course, been an absolute tradition at Joe Public, people like me seem to understand within the law that only evidence which is at the very highest level, as it were, case by case, can be brought to bear, whereas we in medicine, of course, bring everything in. Now, I think the only possible way forward comes back to the question which you were addressing or beginning to at the end of your talk and Q&A session, the relationship between the adversarial system and the inquisitorial system. And it seems to me that a possible way forward would be to really go much more carefully along the inquisitorial line, because of course I do recognize that we in medicine are quite different in a sense. Apart from what I've said, we don't have an adversary other than the illness we're trying to cure. In my case, cancer, that's the obvious adversary. But it's quite different from attacking an individual, as it were. So surely there could be a way in which, using the inquisitorial system, you could operate with a more pluralistic approach to the possible shreds of evidence, however seemingly circumstantial, that might have some relevance.
Thank you very much. I mean, interestingly, we are proceeding a little down that road. So these days, other shreds of evidence are much more likely to be admitted than they were 10, 15 years ago. So there has already been the beginning of that journey. We do preserve, and rightly preserve, the principle that the prosecution must prove the case and must do it beyond reasonable doubt, and that every bit of evidence that is produced must be an admissible piece of evidence. And whilst I have all the concerns that I've set out in relation to victims, I genuinely do not think that we should be adjusting the threshold for defendants in relation to conviction. It'd be the easiest thing in the world to say, well, let's lower the threshold a little so that we don't have to be so sure about guilt, but that would be a retrograde step. So the difficulty that we've created for ourselves is how we improve the lot of victims whilst not undermining the rights of defence. It'd be the easiest thing in the world to devise a system which better provided for victims and undermine the rights of defence, but I'm not interested in that. I'm interested in the much more difficult task of how you improve the lot of victims whilst maintaining the rights of defence. And it means that we will inevitably, therefore, be slower to go down that road and use the same techniques as you would use. We have to try and do it in other ways. But we are at the beginnings of this discussion. It's not a fully fledged discussion even yet.
I think we have time for one more question.
Oh, yeah.
This is not really a question to be answered. It's really a point of information for people within the audience. Currently, at 3 courts within the country, within the criminal justice system, notably Kingston, London, Kingston, Leeds and Liverpool, are running a Section 28 pilot. And the Section 28 pilots deal with the examining or the giving the evidence by ABE interview, so a special interview that is recorded, and then also taking that forward as a cross-examination of the same victim witness, recorded and then played to the court during the trial. The project's been, or the assessment has been going on since the start of this year, and will finish shortly. But I think there's a lot of hope that it will progress and become law in future. But what it means for the victims, who are the vulnerable witnesses, people who are able to give evidence via an ABE, a special interview that is recorded, are now in the position where, having given their interview and the case coming to court, being charged and coming to court for preliminary and subsequent hearings, can then be cross-examined virtually immediately and then go away and forget what happens next. So you pick up your initial evidence, you get your cross-examination when the facts are still clear in the victim's mind. And this works very well where you have child victims of sexual assault or other assault, or you have vulnerable victims who simply couldn't really cope if they were asked to go through cross-examination. The ground rules hearings, which you mentioned, are apparently being really very closely looked at and monitored by the judges who are dealing with the cases, with the result that when you have, for instance, a 4-year-old, and you'll all recall the Baby P case where the child was 3 and making an allegation of rape, the defence will sometimes come along and think it appropriate to set before the court 70-odd questions in cross-examination. But the court is having regard to this and is looking at the questions, looking at the age and ability of the victim to give a response, and therefore cutting this down to reduce the impact of confusing the victim or just simply putting the victim off. And my understanding is that the results so far are reasonably successful, and there is perhaps a possibility that this will continue and become law throughout the country. And that's really a point of information where, in fact, the situation in relation to victims is being addressed in a certain way, and if this works, then things should become easier for them.
They're both steps in the right direction. I completely agree with that and support them.
Well, I'm sure we'll all agree that we have been treated to a most wonderful lecture and most interesting. And the very, if I may say so, very thoughtful and spirited responses, some quite searching questions. I did not detect a single yawn, and not even a suppressed yawn. I think that's a measure of the attention with which this wonderful lecture has been greeted. You have shown us the problem facing victims, how it's extraordinary to think that victims really have only come onto the scene and recognised as having rights and needing protections in the last 15 years or so. That is quite remarkable. And you have exposed quite a number of the very difficult issues that victims and their problems give rise to at every stage of the system. You have really lifted a curtain on a very difficult area of the law in our system. You have told us a lot about the problems. The solutions perhaps are very difficult and to some extent elusive. I think we're very fortunate to have someone like you, a truly reforming person, thinking about these issues. And the idea, well, I think we all look forward to seeing what comes out of your victims' law. But in the meantime, yet again, can I just thank you for a wonderful lecture.